We're ready for our third panel of the day, which is on fashion law and in trademarks, or maybe trademark rights in the area of fashion law. And I'm going to let the moderator introduce the speakers, but I'd like to just introduce the moderator briefly. It's Julie Zerbo, who is founder and editor-in-chief of The Fashion Law, which you should bring up on your computers right now at thefashionlaw.com, and you will see instantly that she is the master of this universe, knows everything going on in fashion law. It's quite impressive, and we're really grateful that you're here to be with us today. Julie.
Thank you, David. My name's Julie Zerbo. We are going to jump right into the panel, but first I want to very briefly introduce our panelists. We have Megan Bannigan here with us, counsel at Debevoise Plimpton, and she is a professor of fashion law at Rutgers. We have Laura Chapman, who is a partner at Shepherd Mullen in San Francisco, where she is the leader of their IP practice group. We have Pamela Weinstock, who is a fashion and entertainment attorney and former VP and Associate GC at Kenneth Cole. And we have Pier Luigi Roncaglia. He's the founder and managing partner of Spherians and an active litigator with many, many, many fashion clients. And so we're going to kick it off with a short clip.
No, and I've seen all this before.
Deskins is trying to reinvent the drugway, so actually
Where are all the other dresses?
we have some right here and then another. And I think it can be very interesting.
No. No, it's just baffling to me. Why is it so impossible to put together a decent run-through? You people have had hours and hours to prepare. It's just so confusing to me. Where are the advertisers?
We have some pieces from Banana
Well,
Republic.
we need more, don't we? Oh, this is Slid. What do you think?
Yeah, well, you know me. Give me a full ballerina skirt and a hint of saloon, and I'm on board.
But do you think it's too much like...
Like the quad from July, I thought that, but no, not with the right accessories. It should work.
Where are the belts for this strap? Why is no one ready?
Here. It's a tough call. They're so different.
Something funny?
Oh. No, nothing's, it's just that both of those belts look exactly the same to me, I'm still learning about this stuff and,
This stuff? Oh, okay. I see. You think this has nothing to do with you. You go to your closet and you select, I don't know, that lumpy blue sweater, for instance, because you're trying to tell the world that you take yourself too seriously to care about what you put on your back, but what you don't know is that that sweater is not just blue, it's not turquoise, it's not lapis, it's actually cerulean. And you're also blithely unaware of the fact that in 2002, Oscar de la Renta did a collection of cerulean gowns, and then I think it was Yves Saint Laurent, wasn't it, who showed cerulean military jackets? I think we need a jacket here. And then cerulean quickly showed up in the collections of 8 different designers. And then it filtered down through the department stores and then trickled on down into some tragic casual corner where you no doubt fished it out of some clearance bin. However, that blue represents millions of dollars and countless jobs. And it's sort of comical how you think that you've made a choice that exempts you from the fashion industry when in fact you're wearing a sweater that was selected for you by the people in this room from a pile of stuff.
And Pam, I think I cut you off there, but want to kick us off? Sorry about that.
No problem. As this great clip from the Devil Wears Prada indicates, And by the way, I wore a little bit of cerulean blue for us today, just in honor of the video. It's such a wonderful illustration of how there's constant innovation in fashion. Fashion, what you really need to remember, is an art form, like other art forms, which we'll speak about in a minute. And inspiration can come from anywhere. Something can really resonate with the public. These days, often it is the direct-to-consumer brands that may have sneakers, Allbirds, Greats, their glasses, Warby Parker. A model that really is authentic, is really digital. That comes from sort of, more of that level up to luxury trying to keep up. And this clip that we just saw actually illustrates the more traditional model that we see in terms of a lot of different fashion houses and brands riffing off of each other, which is really that the luxury brands may come forward dictating something new for the season. It could be a certain look, a shape of a product. It can be a color, as we see her cerulean blue, that will kind of wend its way around the industry, and the different levels will try to do their version of it while doing something that's really on brand for their particular type of customer, but always wanting to stay on trend, as that's really what is going on at that moment and interesting to the consumer. As I mentioned, fashion is really an art form, which it's a very unique animal because it's art that you wear. So, the theme of today's symposium is trademark law and its challenges. For fashion, we've really seen over time that in the US and Europe, which is what we're covering today, it's been a patchwork of laws that have been used in order to protect fashion. And there are more tools in Europe, which we'll hear about later. But some of the things that are interesting is, I guess we can move forward. Did we move past a couple of slides?
Is this the one you want?
I think that's the third one.
That's the first one.
Okay. So again, as I mentioned, fashion is really an art form. Similar to, let's say, music, where there'll be artists that build upon each other over time, and then later, maybe historically, or as we go, we'll come up with titles of genres or movements like jazz or rap music. In visual art, you will have, let's say, surrealism, where you'll have here, Magritte's great painting, The False Mirror, and Dali. Both are trying to get at something that also happened in other movements, in other disciplines, which is trying to really capture things in the subconscious mind. But as you can see, they're all doing it in their own styles and not necessarily riffing off of each other in an exact fashion. Similar here, we have pointillism, which Georges Seurat, you probably know that painting very well, and there's another very famous pointillist, Signac. They both are doing an exploration, more scientific, of how color interacts together in points of light, but they're trying to do it in their own fashion and really doing something that will be on brand for themselves and their art in their own style, but is something that's really going on in the zeitgeist. That's kind of what the way fashion will work. So for instance, and you read every month or so, there'll be these different fashion magazines that come out, and like, Mademoiselle, what's on trend this season? And you may see 4 or 5 items listed, and you may wonder, how are they picking those items? What is happening? I think that the clip illustrated that fairly well, but you can also just really understand here. So for instance, there is in the 20s sort of a flapper moment. It may reflect with the larger society. Hemlines go up, hemlines go down. It's looser clothing that has to do with how women might be trying to position themselves in society at that point. You'll actually see that now. There's a new clothing trend that is big fashion, which looks a little bit like David Byrne's big suit from Stop Making Sense. And people think that that's a reflection of what's going on in Me Too. But again, there may be iterations of that design all over the industry at various levels. And what we're going to talk about today is how can there be innovation while still having protection for the different brands coming forth with their versions. So again, as discussed, there can be different genres that become very popular. Let's say athleisure was a big movement with Lululemon pretty much at the forefront of that. Probably also have to do with society and people really being interested in being more comfortable. Hemlines go up and down in proportion, colors, product preferences. Sometimes there can be one product that catches on, like leggings, which now is a mainstay. You want to, as a brand, be unique while staying on trend and relevant. Sometimes brands really try to develop intellectual property portfolios where they have iconic looks that can last over time, because even though fashion can be very seasonal, there may be something for your brand that you really want to develop a lot of brand recognition in and have it be a mainstay, in which case you may be making more investment behind that in terms of protection. And again, brands have varying approaches, which is generally led by where they sit in the marketplace. For instance, the luxury brands that we're seeing do tend to really try to put a lot of development into these features, and there may be sort of, more leaders and followers in the industry.
Perfectly pass that down. And Pam touches on a really important and relevant point, in that brands do in fact have varying approaches and evolving approaches to protection and enforcement. Fashion is a particularly interesting, in my opinion, and I think the rest of the panel's opinion, when it comes to protection, because it is really steeped in a culture of inspiration, as Pam touched on. And, so much in fashion has already been done before. We didn't, but somebody saw jeans being shown for the first time back in the late 1800s. So much has already been done that designers are consistently looking backwards and incorporating some of those staples into the products that they're showing on the runway today. Given the cyclical and inherently inspirational nature of fashion, it gives rise to some interesting issues when we think about protection and when we think about inspiration and copying could or could not mean infringement. And so we have a few quick examples here just to give you an idea. In this instance, a Scottish designer called out Chanel for copying her Fair Isle sweater design. An English designer and artist called out Versace on Instagram, where a lot of these call-outs are taking place, for copying the print on her t-shirt and then marking it up by $600. And then this one actually ended up being a short-lived lawsuit in which a graphic designer named Jimbo Phillips sued Jeremy Scott based on copyright infringement claims, saying that he took a bunch of the graphics and creative designs that were on his skateboard decks and put them on miniskirts and bustiers. That case ultimately settled. But let's see. Those examples kind of give a representation of some of the issues that we commonly see in fashion when we're trying to distinguish between inspiration, which is necessary in fashion, and imitation or infringement, which is when inspiration goes a little bit too far. Like I said, in terms of protection, fashion is a compelling medium in large part because there isn't a one-size-fits-all protection avenue. So brands and their councils look to a number of different options to protect their original and creative things. Copyright law is one of the, is one of the forms of IP that makes the most sense because it protects creative things. It can be difficult for brands to, fashion, no pun intended, copyright protection for them because copyright protection refuses to provide a monopoly for useful things, and garments and accessories are primarily useful. That's not to say that creative elements of fashion designs, whether it be lace or prints that appear on garments or jewelry, are not protected, because in many cases they are. It just becomes difficult because of that useful article separability doctrine, which kind of puts us in the Star Athletica versus Varsity Brands realm unavoidably. This was a case that, if you don't know, went before the Supreme Court. They had oral arguments on Halloween in 2016, and it was a case that centered on copyright infringement claims between two cheerleading uniform manufacturers that were taking issue over the stripes and the chevrons on the uniforms. The Supreme Court ultimately held that creative elements, original elements of design that appear on garments may be protectable, and they fashioned a new test for separability, which you can see up here on the screen. And basically it said a feature can in fact be protected if it can be perceived as a 2 or 3D work of art separate from the useful article, and that would qualify as a PGS work if imagined on its own. And so courts or other brands have taken to citing that case in adding copyright infringement claims to their cases. Shortly after the Supreme Court issued their opinion, Puma cited that case, adding copyright infringement claims to its trade dress and design patent case against Forever 21 for copying shoes that were part of pop star Rihanna's collection. Trademark protection provides some leeway for brands to protect word marks, symbols, logos that appear on garments and accessories, but doesn't traditionally provide protection for the garments and accessories themselves. And while design patents do make for appropriate protection for useful things like garments and accessories, there are some practical concerns for a lot of brands. One of them being the pendency time for getting a design patent. It's just not really in line with the seasonal, trend-driven, increasingly quick nature of fashion seasons, and they're relatively expensive for a lot of brands in the fashion industry. And with all of this in mind, it brings us to the idea of trade dress protection, which is important for brands. It's an important form of protection, and it's one that brands are looking to and have been looking to kind of bolster their protection strategies as they continue to push the envelope and try to come up with a patchwork system for protecting all different elements of their brand. Trade dress can protect everything from the design and the shape to configurations generally. And it's also not super straightforward because of the secondary meaning requirement, and that's something that Laura is going to touch on for me.
Sure. Hi, everybody. So between our two firms, Megan's firm and I have litigated 4 recent cases that involve trademarks over product features on apparel. So I just wanted to take a few moments to talk about the trade dress that was involved in each one of these. The one on the far left was handled by Megan's firm, and the claimed trademark there was quilted fabric for use on bags. The second case I was very involved with, and I see other people here. I see Helen Hill-Metzer's here today from Banner Witkoff. She and I spent a fair amount of time in deposition in this case. And that case, the claimed mark, and Megan's firm was involved as amicus on appeal. In that case, the claimed mark was a portion of the design of the Chuck Taylor sneaker made by Converse, and they had claimed the design of the toe cap, the design of the toe bumper, stripes at the midsole, and the combination of those elements together. Now, it's sort of interesting to me for two reasons. And there are many interesting things about all these cases, but two things sort of stick out to me about this Converse case. One of them is that only a portion of the design was at issue. And the other is that the design as we know it today that was claimed in the case, which was started off in the International Trade Commission, at the ITC. The thing that was interesting about it also is that the design was first really popularized in the 1950s. So talking about secondary meaning becomes very interesting. The third case is a case that Forever 21, we instituted a declaratory relief action for Forever 21 against Gucci, and the issue, what was interesting to me about this case is that it's stripes on clothing. They had incontestable registrations for stripes on accessories. They did not have any incontestable registrations for stripes on clothing. So that brought up some heavily litigated issues. And the fourth one is also a case we were involved with in which Puma claimed the entirety of the design of what is called a creeper sneaker that, or sometimes it was in the past called a brothel creeper. And it was a style of footwear that first became popular after World War II. And in that case, the entirety of the design was claimed by Puma. The issue in each of these cases is whether there is secondary meaning in the claimed design features that are part of the products. And before you can get to how to prove or disprove the existence of secondary meaning, you have to first make sure you identify and support or attack what the elements of the claimed trade dress are.
And so the first step in having a protectable trade dress is being able to actually define what that trade dress is. It sounds simple. It's not a new concept. It's actually black letter trademark law. You need to be able to precisely and expressly define what your trade dress is. So why are we talking about this today? Because over and over and over again, it keeps coming up that parties aren't giving enough thought to consistently and precisely defining what their trade dress is. This becomes really important at various stages of a trade dress enforcement proceeding or any trade dress litigation. We'll look first at the Alaïa v. Steve Madden case. This was a case, the issue was the trade dress over these shoes that you see here. Alaïa has the colorful shoes. Alaïa claimed that Steve Madden was infringing its trade dress in these shoes. The Steve Madden shoes are the shoes on the left. Alaïa filed a complaint. It listed about 6 elements that it said made up this trade dress. It included things like, multicolored woven bands throughout the front of the shoe, closed toes with an angular shape at the top of the shoe, and a few other elements like that. And the court took one look at this complaint and said, all I see here is a laundry list of elements. That's not enough. In order to actually state a claim, you need to tell me why these elements are distinctive, and you need to tell me what makes this special, that it's subject to this special trade dress protection. This was interesting because the court was really willing to go the extra mile and really impose a slightly higher burden on the plaintiffs to say, don't just show me a picture and tell me something is protected. Tell me why this actually deserves protection. Why is this an indicator of source? So certainly something to think about if you're going to file a trade dress claim. Make sure you're actually defining your claim and saying, why is this a unique design? As a defendant, it's also something to keep in mind because the courts are certainly showing a willingness to engage at a motion to dismiss phase, which is obviously a much cheaper option to defend than having to go all the way into discovery. Very quickly, this is another case. And I should mention that the Steve Madden case was just affirmed by the Second Circuit a couple of months ago. This was another case also affirmed by the Second Circuit this fall. Here, the issue was the trade dress over this inflatable swan pool toy. There was a company, they had made the swan for years. They sued another company saying, hey, you're infringing our trade dress in this swan. Here, the court was so irked by this complaint because the trade dress, they couldn't even define the trade dress consistently in their own complaint. At one point they said, we're looking to protect this swan toy. At another place they said the swan toys, the product line, the swan toy, and 3 other distinct toys. It was just all over the place. This was also the second amended complaint. And the court said, this is sketched at way too high of a level of generality. I don't see any way how this could be protectable. It's interesting, and this swan is perhaps not the best example because it's, really questionable at best whether this could ever get trade dress protection. But the court, basically said, I see absolutely nothing here. You can't possibly have secondary meaning. This is generic. But look, trade dress protection is based on this idea that even if your design is very descriptive or very general, if you make that investment, and I could be talking years and years of use and also investment in consumer recognition, but if you get that consumer recognition, you can get trade dress protection even in something general. And the court here is willing to say right off the bat, no way, this is generic, dismissed with prejudice. So again, just a perfect example of why if you're actually going to follow through and file one of these complaints, make sure you're doing it with specificity. Make sure you know what your trade dress actually is. But the motion to dismiss phase is not the only place this issue of consistent articulation comes up. It can actually also impact whether you have secondary meaning or not. And so this is the M.Z. Wallace case that Laura introduced. Here, M.Z. Wallace sued Oliver Thomas, again, trying to enforce the trade dress in their nylon quilted bag. This case went to trial in the STNY just in December. It was decided in December. As Laura said, there was a Debevoise team that represented Oliver Thomas. I'm happy to say that we won, and the trade dress was invalidated. The alleged trade dress was invalidated. But one of the arguments we were able to use is that M.Z. Wallace, over the years of attempting to enforce this trade dress, had been so inconsistent in the way that they were actually describing the trade dress. They had sent out various cease and desist letters. They had filed various applications at the PTO, all of which were denied. But in each one of these things, they defined the trade dress differently. They couldn't decide on one definition, and it was basically, whatever bag they were looking to enforce it against, they defined the trade dress according to that bag. Obviously, Judge Cote did not agree with that. She added some pretty strong language to her opinion that said, M.Z. Wallace utterly failed to show that the definition of its trade dress on which it settled just this year has achieved secondary meaning. We were able to present this very effectively to the court. We actually used a chart that looked like this. On the, in the white column here, you see a list of all of the parties that received cease and desist letters or the PTO applications. And up top, you see the different elements that were in the various claimed trade dresses. In the green, it appeared in the letter. In red, it did not. At the bottom, you see Oliver Thomas's, both the cease and desist letter they got and the complaint. The trade dress wasn't even described the same that way. And the court absolutely loved this demonstrative. She actually copied and pasted it directly into her opinion to make the point that if you can't even say what your trade dress is, how can you possibly say others are supposed to see it and recognize it as MZ Wallace?
Can you go back 3 slides, because I want to look at this picture.
If they said
We can't go back. Okay. There are lots of issues that come up in terms of how to prove, yeah, I'm going to, how to prove or disprove secondary meaning. Courts really like survey evidence. There's lots of cases where courts say consumer survey evidence is a great way to prove what consumers perceive and whether they associate a particular mark or designation or product feature or design with a particular source and a single source. And there are so many issues involved in surveys, we could not possibly get into them today. I will say that sometimes, you know, obviously it's important to do as much survey work in advance as you can. If you are on the receiving end of a complaint, you don't necessarily have time on your side in terms of the luxury of advanced preparation. And in the Converse case, when we looked at secondary meaning, we worked with an expert and we decided to test 2 different instruments. We used 2 different designs. Because the trade dress at issue was only a portion of the shoe design, we thought, well, let's just test that portion, just this kind of free-floating combination of elements that wasn't really connected to a shoe. There was some debate about that, but we did that. And then we also took that midsole design and we put something very different on top of it, which looked like a shoe that a very elderly person would wear, which we would joke was the granny shoe. And it's sort of interesting to me because the International Trade Commission did not like the granny shoe. So they rejected that one, but they did find that just testing the design by itself without being connected to the rest of the shoe design was acceptable and was determined to be good evidence that there was secondary meaning was lacking. So like I said, there's so many issues on surveys, we really couldn't go over many of them here. So I'll go to a different issue, which is advertising. Advertising is another important way that you can establish secondary meaning. And I think that when if what's at issue in your case is not a word mark, but it's a product feature or a portion of a design of a product, I think it's very helpful to take a close look at what the advertising consists of and the scope of the advertising. And this is fiercely debated depending on which side of the case that you're on. But there's case law out there for the proposition that sort of the gold standard, at least, is going to be look for advertising. And look for advertising calls out that portion of the design that your client is claiming as a trademark or that you are arguing should not be deserving of protection. And it's different than just advertising the word mark or a logo or the entire product. And sometimes there are great examples of look for advertising that if you're the plaintiff or the claimed rights owner is going to help you strongly in your case, and sometimes they're not. But one example that I think is a really great example of look for advertising was done by Christian Louboutin, and I hope I'm pronouncing that correctly. I took high school French, but I'm not sure I did a great job at that. But anyway, so everybody knows, I think probably everybody in this room knows, that Louboutin obtained a registration for a lacquered red sole. And what's great about this little ad, which I have 2 still images of, is one of the opening images is of the designer lacquering on, painting on the red paint onto the sole of the shoe, and there's another image of the red footprints left behind. If you actually look closely, he's painting it onto a stiletto shoe, but the footprints show actually a pretty chunky heel, so it doesn't actually match up, but that's the technicality, I suppose. But anyway, I just think that's a great example of look for advertising, and so when you're litigating this kind of case, take a close look at what the advertising actually is featuring and calling out, and use that depending on, if you can, depending on which side of the case you're litigating.
And if I might just pop in from an in-house perspective on that point, which is a great point, it's very important to always work very closely from the get-go with your marketing teams and your design teams in order to identify the features you believe really should be protected by trade dress. They may say everything, but you really, if you're going to be creating special look for advertising or calling out certain features very distinctly for the public, you need to identify which ones, understand why, and get in there early so that this kind of thing can actually happen.
Well, and that's a perfect segue into this next example, which is, if you're, trying to enforce your trade dress and you're saying, this is what my trade dress is, but your branding team is putting out an advertisement, actually look for advertisement, saying, look at this diamond leather logo. That's how you identify the source of our bag. But you're in the midst of litigation where you've said, no, the actual way you identify the source of the bag is through the quilted pattern, and that leather diamond's not included in the trade dress you're trying to protect. It's actually going to hurt you. And what the team was able to do at the MZ Wallace trial is they got MZ Wallace's witnesses to admit they hadn't done any look for advertising for the particular trade dress, but in the middle of the litigation, their marketing team made this social media post that was, frankly, contrary to what they were saying was their source identifier. That alone isn't going to be enough to decide a case, but it certainly doesn't help. And it makes Pam's point, make sure everybody's on the same page and your marketing team's not working against you. Social media, trade dress, social media comes up in so many different ways now. Obviously, influencers are the way that the market is moving. We're so reliant on our phones. We look to our phones for everything. So brands have jumped onto this, and they're advertising their goods. But if you don't know what your marketing team is doing, if you don't know what your influencers are doing, that can actually hurt your trade dress rights. And so here, these are just some examples. You have a hashtag ad here, so you have a sponsored influencer, and she's touting the MZ Wallace bag, but she's touting it in a way that talks about how functional it is. Let's see, it's lightweight, it's water resistant. You have another example here. Here's an influencer using a hashtag that MZ Wallace actually created, which is hashtag functional luxury. And all of this works together, is this actually a functional design? And the court didn't call out any of these specific posts, but it said in the background section of the MZ Wallace opinion that in advertisements and internal documents, it constantly touts the functional nature of its own designs. The court didn't have to get to the opinion of whether the MZ Wallace design was functional because it decided off the bat that there was no secondary meaning. And again, this isn't alone going to say, oh, it's functional, it's not a protectable trade dress. But you really need to watch what your influencers are doing and your own marketing team is doing, because it can come back to bite you.
And again, on influencers, which many brands are using these days, in order to probably make sure that what you want to be focused on is, it is probably also very important, that whole holistic approach to really identify the kernel of the message you want out there on your brand, and make sure that influencers, or often, as you know, there may be companies that bring in influencers for you, so it may be a couple of steps removed from you, and influencers always are going to post their take and what they want to say, but it's important in the relationship, again, to always boil down and really make sure that these kinds of things are, you know, kind of front and center in their thought process about the brand.
A key issue in these cases involving product feature or product design trademarks is whether the claimed trademark owner has had substantially exclusive use of the design at issue, and the effect of third-party use might have on consumer perception as to whether the claimed design signifies a single source or particular source of the product. Litigation can involve surprises that I think Megan was alluding to earlier. Sometimes things come out and they can be good for you, but even good things can sometimes be surprising to you. In the Converse case, I think we were surprised with how much third-party use there was over a period of time for many decades. Just the amount of so-called, you know, prior art references, to borrow a patent concept, was significant, and like I said, frankly, almost surprising to me how much there was. Hundreds and hundreds of examples. This is another same concept here in terms of other examples, contemporary and third-party use of designs. And I think that goes back to why survey evidence can be so important, because what you want to look for, what the courts are going to want to look for, is what effect does all that third-party use have on how consumers perceive the designation or the design? Does it operate as a trademark?
And so quickly, just touching on that point, you know, as Laura started to mention, that, you know, where we see a design where the trade dress was really inspired by, you know, historical context or designs with cultural significance, which we see a lot of, you're going to have a much harder time proving that consumers associate those designs with your particular company. Oftentimes, designs with cultural significance, you know, they're produced by many parties. It's not just one party that says, oh, hey, I've noticed this culturally significant design. You know, they're out there, they're in the industry already. It doesn't mean you can never protect something that was used historically or that's culturally significant. But you really have to be the only one who's doing it, or the first person who's doing it, and make sure you can get that secondary meaning. So this, you know, we can talk a quick example about the recent Steve Madden v. Cult Gaia case, and that's exactly what happened here. Here this involves the trade dress rights in a historic Japanese bamboo bag. Cult Gaia put out its version of the bag. Steve Madden had its own version of the bag, and you see here on the bottom right one of the vintage Japanese versions of the bag. Cult Gaia sent Steve Madden a cease and desist letter and said, hey, this is my design, you're copying. And Steve Madden said, what are you talking about? This is, you know, a culturally significant design, and in fact, it's all over the industry. How can you say you own this? We're going to file a declaratory judgment action that says, you know, not only are we not infringing, but you don't have any protectable trade dress in this design. So this is an ongoing case. Like I said, Steve Madden's case is bolstered by the ubiquitous use of this bag throughout the fashion industry. These are just some examples taken from the complaint of different companies that have put out very similar bags, which will certainly undermine any claim by any claim by Cult Gaia that it has secondary meaning in this bag. You know, but that brings up the question: if third-party use is, you know, a really core of your defense, you know, you've been hit with a trade dress infringement suit. You say everybody is doing this. You know, how could anybody possibly own this particular design? we just need to show the court the fact that all of these other parties are doing this. But what's sometimes overlooked when you're defending one of these actions is how do you actually put in this evidence to show there's so much third-party use in the marketplace? And, sometimes you think, well, let's just get the bags, or let's just show internet pictures, and we can show the court that there's tons of other things out there, and that settles that. But that's actually not the case. And there's actually some, slightly unclear precedent, especially in the Second Circuit, that says, if you're trying to use third-party use, it's not enough just to show that these other products exist. You actually have to show that consumers recognize that these other products are out there. And so there's the Second Circuit case that says that, Scarves by Vera. But the problem with Scarves by Vera is it says exactly that, but it doesn't say anything more in terms of what you need to show consumer recognition of these third-party designs. And there's some inconsistent cases that follow. So when you're thinking about actually preparing a case for trial or preparing to present your evidence, you need to make sure you have more than just the fact that there's, somebody somewhere was at some point using a similar design. What some cases have suggested is this means you need to collect sales data or volume of sales, how much has been sold from other companies, from these third parties. That might mean, unfortunately, having to send out subpoenas to these third-party brands to collect this information. I know there are a few subpoenas from the MZ Wallace case, recipients in this audience from the MZ Wallace case. I heard a few stories at dinner last night about that. But MZ Wallace, Oliver Thomas, let me back up here. In order to defend against MZ Wallace's claims, Oliver Thomas unfortunately had to go out and collect all of this information of sales and was able to very effectively show that there are a ton of quilted bags on the marketplace and people are buying them. There's a very recent case in the Southern District of New York from Judge Rakoff. This involved Swell bottles. And here, the other side didn't produce evidence of sales, but what they did produce was the fact that there was 130 bottles that they had, and Judge Rakoff took the 130 bottles into evidence. He said, this isn't enough to prove secondary meaning because we don't know exactly how they're used, but the fact that the sheer number alone and the fact that if you look at the context of where you were able to collect these bottles from, he specifically pointed out there was a trade show that 4,000 people attended, and these bottles that looked like Swell bottles were all sold there. Apparently, if you type in this shape water bottle on Amazon, bottles that aren't Swell bottles pop up. So he said, this isn't enough on its own to show secondary meaning, but it's certainly not meaningless. So he does open the door a little bit. Maybe you don't need to put in sales figures, but it will definitely depend on the context. And to the extent you're relying heavily on third-party evidence, you need to make sure your team is taking steps to put in more than just the fact that these third-party designs are out there. I think we can skip over this one.
So, Megan and Laura, before I pass it off to Pam for an in-house perspective, what is one thing that brands need to be thinking about in terms of trade dress enforcement? I know we touched on a few things, but if you had to give one takeaway.
I mean, I think what some of these cases show is that it's still really hard to get design protection in the United States. And that's purposeful. There's no, specific protection for designs. So you need to show your design is really unique and special. And to the extent you're looking to enforce your design, make sure you have your ducks in a row. Make sure you can define your trade dress. Make sure your brand team is on point with you. Otherwise, you really face the risk of getting somebody on the other side who says, hey, I'm going to seek to invalidate your trade dress. I'm going to file a declaratory judgment action. I'm not going to back down here. And from a defense point of view, that can be a very, very effective strategy. Do you want to add to that?
And I would just add on a very practical level, be prepared to devote the resources and secure the budget because if somebody does challenge you, and we were talking about cease and desist strategies, and I never tell anybody we're going to, or declaratory relief strategies. I don't like telling people we're going to do it. I don't like making that part of a discussion. I think if you're going to do it, just do it. But then if you get that, you're off to the races. So just build, to avoid surprise. So much of what I know we do as outside counsel is try to avoid surprise by the client, and I'm sure in-house people feel that's really important to make sure their business and design people are not surprised as well. So understand there could be a significant financial commitment can be involved in this quest to seek protection over design elements.
And Pam, I know that you've had a few in-house excerpts here, but can you kind of build on that?
Well, I think that a lot of people in the industry, we talked a lot about litigation today, but a lot of people think that if you're sued or if there's litigation, you've already lost. Basically, I think that there are a lot of steps to take from the get-go and also potentially in working things out prior to litigation, because for many brands there is so much money and resources that get diverted when you have a large battle in court. There are some brands that really do put a lot of money also behind enforcement and can build up very strong marks, like for instance in stripes, Google Adidas, you'll see a lot there. I think that there are a lot of luxury brands as well, in particular, that really put a lot of budget, a lot of investment into looking at what can be something iconic that can move forward in time with our brand as design that we can point to and look for advertising, as well as just continue on in our product lines over time, because again, fashion does run seasonally, but there definitely can be features that you're using on a long-term basis that you can build up a lot of goodwill and that can be very associated with your brand and have secondary meaning. One thing to do is to, I don't think we've moved this forward.
Oh, I think we have time for
Fine.
one slide,
Okay.
unfortunately, and then we have to talk.
Then I will just run through very
about
quickly so we
Europe.
can get to Pierluigi. Basically, if possible, it's good to try to elevate to the C-suite and to the heads of departments the need to really focus a lot of energy and budget on your brand and on developing these sorts of elements over time. It can really add to brand value. These days, intellectual property is very important. You want to also work with your design teams very closely. There are a lot of industry legends that circulate you may have heard, which I have heard in many companies. They'll think if you change 20% of something you see out there, or if you change 3 elements that you're good, you're not. You need to kind of let them know it's not that simple and really get involved in line review. So that at every stage, so that there's not disappointment later on if people become very wedded to a certain product or certain type of thing going forward. You don't want them to really have something coming already from the factory when you first look at it. That would be not a good thing. And I think just as far as the different types of products and features that you come up with, you will want to take a review for what is the best protection of the individual feature, and is it going to be distributed around the world, leading into your section of this, because there are different protections globally for product features and design that I will turn this over. Go forth with
Okay.
Europe.
Thank you. Yeah, let's look at the weird European perspective now. As we just saw, there's a very well-established trade practice among luxury brands and fashion brands of using, in addition to watermark, of using features, product features such as patterns, colors, clasps, and so on, or the whole product configuration as a source indicator. These are some examples, and I will sure you're familiar with, yellow well stitching at the Dr. Martens boots, the canage pattern of Dior, the red tab, Levi's red tab, or the blue collar of Tiffany. Well, in Europe, unlike the US, product configuration can be inherently distinctive. But our case law recognizes that since consumers are not really in the habit of perceiving product configuration as source indicators, it takes a little more to be registered on the basis of inherent distinctivity. What we say is that shapes have to depart significantly from the norms and customs of the relevant trade. This is an example. The Technica Moon boot was considered registrable on the basis of inherent distinctiveness because it was very different from whatever was out there at the time it was filed in 2012. Well, one of the problems we have in the fashion industry is that once a shape departs significantly from the norm and customs, chances are that that shape gives substantial value to the goods. For shape marks to give substantial value to the goods is the European equivalent of aesthetic functionality under US law. So it's an absolute bar to registration that cannot be remedied on the basis of secondary meaning. So this is like usually this impediment is something that is not brought up. It's brought up very often in litigation as a defense, but not very often upheld by European court. This was an interesting case that involved the red sole by Louboutin. They went all the way to the Court of Justice, and the question to the Court of Justice was whether the red sole could be considered the shape of the goods and therefore whether it could be aesthetically functional. Well, in that decision, the court basically established that it was not even a shape because it was not the whole shape of the goods, so the impediment of this provision would not apply to the red sole. That was the conclusion of the case. Interestingly, right after this case was decided, we changed our law and now we made it a little broader. So this impediment does not apply only to shapes anymore, but it applies to any characteristic of the goods, which raises also an interesting question with respect to the transitory regime of this provision. What happens to shape like the Louboutin red sole that was filed under the old law? Would the new broader impediment apply to them? This is something that has been posed to the Court of Justice again not longer than a month ago. We're waiting for the decision, but in the meantime, there was a decision from the General Court in the Pirelli case that already took the view that no, this provision is not retroactive, and therefore marks that were registered under the old law would be limited to those impediments that were applicable under the old law. Substantial value to the good, what is it? It's a market approach that we have to look at. A product, a sign gives substantial value to the goods when the shape is the main motivation, at least one of the fundamental motivations to make that specific purchase of that specific product. These are some examples. The G-Star jeans was considered giving substantial value to the goods. On the other hand, in a court decision in Italy, the Birkin bag by Hermès was not considered to be giving substantial value to the goods because it wasn't very special. It wasn't very different from what was out there. So if anything, he had an issue on the basis of distinctiveness, lack of distinctiveness, but not for giving substantial value to the goods. One good example is the Bang & Olufsen speakers. And of course, you buy a speaker because of the quality of the sound. That's the main reason why you buy a speaker. But in this specific case, the court took the view that the looks of that specific speaker was so important that it influenced predominantly the choice of the product. And therefore, there was a bar to the registration. Going back to distinctiveness, when a shape does not depart significantly for the norms and customs, it can be registered only on the basis of secondary meaning, like it is in the US. The problem is that after a long debate, we just had in May of 2018, a decision for the Court of Justice that established that when you have to prove secondary meaning with respect to a mark that was filed or registered in the European Union, you have to establish secondary meaning in each of the 28 member states, which even for the owners of very famous trademark is something almost impossible to do, which basically kills the possibility of registering shapes on the basis of a secondary meaning. The situation is not much better with respect to registered marks that were registered, because at least so far European courts, and also the office sometimes, the way I see it, have been a little superficial in interpreting the prerequisite, the burden of proof in invalidation action, which should be on the defendant, and the presumption of validity of the registered mark. I'll give you an example. This was a mark that was registered by Louis Vuitton. It's called the Damier. It was recently canceled. The case is still pending, but it was canceled by the board. This was a mark that was registered in 2008. So if you want to cancel this mark, you have to show what the norms and customs of the relevant field, which was Class 18 goods, so leather goods, was in 2008 when the mark was registered. Well, this was the evidence that was brought in this case. So here is only clothing, is not even Class 18 goods. Here you see some bags, they're kind of different, but mainly none of this evidence had a date. So it could not prove the norms and customs at the time the mark was filed. But nonetheless, it was canceled. On the bright side, once these marks are registered, I mean, when they make it to be registered, the protection they can have under European law is generally speaking much broader with respect to the protection they enjoy under US law. Two things mainly, or three things I should say. Likelihood of confusion or association is established much more in the abstract, which means that the difference in price, the difference in quality, the difference in the channel of trade, they're all irrelevant. The fact that these marks are accompanied by a different house mark, irrelevant too. You also look at the product coverage with respect to the way the mark is registered and not with respect of the actual products for which the mark is used. So all of these things make it easier to establish a likelihood of confusion. In addition to this, marks enjoying a reputation are not protected like in the US only against dilution or tarnishment, but they're protected in any situation in which the user of the subsequent mark takes unfair advantage of the reputation or the distinctive character. And the vast majority of these cases are decided on the basis of the taking of a fair advantage, also because it's much easier to prove the fact that you take unfair advantage because the intent is always very clear in this situation. These are some quick examples of enforcement in Europe. As you can see, this is the Louis Vuitton 12 monogram that was enforced against a variety of marks that are not even that similar, if you think about it. This is the Gucci, the famous Gucci green, red, green web that, unlike in the US, was protected, even if it was registered only with respect to clothing and Class 18 goods, was protected even across different categories of products. This is the Ferragamo Gancini device mark, and you can see cases in which it was protected against other famous companies using a different watermark. This is the Burberry check, protection from identical checks, more similar checks, you see 2 line for lines, all the way to the protection of sinks, and also home. This was a Balkan town that I don't know why they decided to paint homes like with the Burberry check, and, or this is the shape of the Panerai watch with its distinctive feature, the bridge, that was protected in the case in which the infringing product was a plastic watch. It cost $100 instead of several $1,000s. It had a different wordmark, but nonetheless was protected. Another reason why protection is usually broader in Europe is because we really have no parity defense against trademark infringement. Despite a proposal when we change our directive from the European Parliament, sustained also the Max Planck Institute, of including parity as part of fair use of a trademark, also thanks to the efforts of MTA, this provision didn't make it into the directive, so parity is not an excuse. So cases that you know very well, like the Louis Vuitton case, or the My Other Bag case, which were decided in the US against Louis Vuitton, would have had a completely different outcome in Europe. And you can see this case, for instance, is the exact equivalent of the My Other Bag case. I left the original at home, and it was decided in favor of Louis Vuitton in Italy, and same thing for Louisa and Victoria with some reminiscent trade dress that was also decided in the favor of Louis Vuitton. Now we'll see what happens to the Louis Vuitton case that is simultaneously pending in California and Paris, and I'm expecting to have an opposite outcome probably in California and Paris. If we go quickly, in 1 second, beyond trademarks, let's look at one last thing that Pam was referring to that we have in Europe and you guys don't have in the US, is a registered design. A registered design is a tool that was specifically designed for the fashion industry to give owners the possibility of protecting design without having to go through the trouble and expense of registering design. You get your protection if your design is new and has what we call, individual character. You can get protection against identical or virtually identical copies as long as these copies are intentional. It could be a limited protection with respect to registered design, but nonetheless is very useful. This is a recent case in which Louboutin had a registered design right on his Kaleikita shoe, and he was able, even if he didn't have any registered design, he was able to obtain a pan-European injunction against the infringer in a situation in which probably on the basis of unfair competition or copyright would have not been able to succeed.
Whew, you did so well, Pierre. Before we get off the stage, does anyone have any questions? Oh, I think we have one down here. No.
Hello? Oh, yeah. Thank you. That was very interesting. I have a question. In the previous panel, we witnessed the great relationship between the legal department and the marketing department at Sony. So we all heard of what happened to Dolce & Gabbana with their advertisement in China. So my question is, how could a company like Dolce & Gabbana with over $1 billion revenue make such a huge mistake? Do they have the same relationship in the fashion industry? And finally, what the D&G in-house or outside counsels could have done to prevent the company from making such a big mistake and eventually damaging the brand in a permanent way?
I think you're referring to the ad campaign image where they are using an Asian model who's holding chopsticks to try to eat pizza.
Yeah.
Do you want to take this one, Pierre?
I don't think you went to outside counsel, at least in Italy. So
Right.
I can tell you that much, and I can't really comment more.
Someone suggested I put that in my cultural appropriation slide, and I politely declined.
Yeah.
I mean, I personally think it shows a bit of a lack or a lag behind for some fashion brands as their brands become truly global in nature, and the need to really adapt their advertising geographically speaking. So you have geographically specific advertising as to not alienate your audience, especially China, which is such a big audience. It seems like a huge oversight. Pam, you might have some thoughts.
Right, as you're expanding internationally, it's very important to work with international departments, and if you don't have that expertise within your own company, to have experts in those regions let you know what is and isn't acceptable, what also may be insulting, or what may just not be appropriate, for instance, in the Middle East, or this is throughout trademark law, there are certain words that translate problematically in certain areas of the world, or just images will not come off right, or even if you have slogans, or you have sort of witticisms in your brand, you need to translate them, and you need to make sure that that humor is understood and it will come across the right way, and also different topics that you might focus on that maybe more progressive here for certain things as in different areas of the world. So all of these things, I think it's just really important to be mindful of that. And from a business perspective, to again align very closely with your marketing and branding departments about advertisements around the world.
Last question.
So you mentioned the importance of social media, and there have been the increasing accounts of these sort of intellectual property, how do you say, like, vigilantes, such as Diet Prada and other Instagram accounts that have sort of taken the law into their own hands and are calling out these brands. How much of that reality has been factoring into your, legal advice or legal strategy for brands?
I mean, this is certainly popping up all over the time because no longer it's just somebody sending you a cease and desist and saying, stop copying my design. You're getting people posting very publicly on Instagram, calling you out as being a copier. And many times you see that happen when the person saying you're a copier clearly doesn't know the trade dress law. And we've had a situation, I've had it in cases that aren't public where we've responded and said, not only are we not infringing your trade dress, but we've seen what you're doing on social media, and if you don't stop, we're actually going to sue you for disparaging us. But it's also coming up publicly. It came up in the MZ Wallace case, and there the court specifically cited the conduct as being unsavory, saying, we look down on this type of conduct. So, it's something that we're going to continue to deal with, as social media obviously isn't going anywhere, and people really like to speak their mind. And frankly, sometime in an anonymous nature or a pseudonymous nature. But, as a brand, if you see it, you can certainly take action and write to that person and say, cut it out.
There was
or
actually,
change your ways if you need to.
There was a recent article, just sort of mentioning what I said before about, when you go into litigation, that's already a problem. There was an article recently about how instead of doing that, or instead of the cease and desist, how the new movement is really to call out people for copying. Everybody sees it on Instagram. It's like the court of public opinion. Even sending out, I think we were talking about this, cease and desist have to be crafted very carefully these days because it is a PR matter, because people put them up immediately on the internet, and we've seen a lot of good and bad examples of that. So it's really, I would say, a different world.
All right, thank you very much. We're going to take